Well, hey everybody, I'm here today to do a short lecture on workers' compensation for the Intro to Paralegal class. My name is Rob Dawalt. I put my private email up there in case you ever need to reach me and you can't remember the school email. That one's a little bit easier, so if you'd write that down, you probably can rely on that if nothing else works. If you notice, I've got down here, and this is important, Indiana Administrative Code, Section 631. Now, it's mentioned in your sessions for your online class, an Intro to Paralegal. But the thing to understand is this is not Indiana Code, this is Indiana Administrative Code. So basically what we're working in is we're working in the area of administrative law, which covers a number of different things, and a lot of the misunderstanding about administrative law is that it generally emanates from or comes out of the executive branch or the legislative branch, not so much the judiciary. It's kind of like a pre-litigation requirement, and generally speaking, in the case of workers' compensation, it's the only real remedy for employees against their employers, especially in Indiana. One of the things you need to understand is that around the early 1900s there was this national move toward workers' compensation. It was called workmen's compensation back in those early days. And what happened was that the legislatures actually developed this new set of statutes which really took away the right of an employee to sue their employer for a lot of different reasons. A lot of them involve physical injury, of course, like on machinery or by co-workers or anything like that. But this was a big step, and to me, fundamentally, I question whether it's even constitutional. Of course, it's been found constitutional time and time again by all the different Supreme Courts. And it's apparently within their purview of making laws and so forth. But I really think from the standpoint of the 14th Amendment, it makes me really question, because what would be the difference between, and let's say, an employee with a claim against the employer as opposed to an employee with a claim against a private person for similar acts? I guess it's this employment connection is the reasoning. But I also have this sneaking suspicion that, him with the gold sets the rules. There's an old thing called the Golden Rule. It's been around since Confucius' time. And basically what it says is do unto others what you would have them do unto you, or basically what they call the Golden Rule. But the street name or street parlance is them with the gold rule, or set the rules. So the problem is that the industry is much larger than people as far as employees, unions, and so forth. And so they've been able to put this in place. It's been in place now over 100 years. And basically what it does is does lower the standard of proof. So there is an advantage there for employees. If they're hurt at work, basically, it's very difficult to not get some kind of compensation, even though companies and insurance companies especially a lot of times will initially deny claims and say, oh no, this is not contemplated in a workman's compensation law. But in many cases this has been granted, and we can look at those by looking for cases on workers' compensation even in Indiana. Another issue I want to talk to you about is, let's say that you're a truck driver, or that someone is a truck driver, a client is a truck driver, and they work for a company out of, let's say, Normal, Illinois, or somewhere like that. But they live in Indiana. Well, where do they have to file their workers' compensation claim, and why is that important? Well, it's important because the benefits in Illinois are much better than they are in Indiana. In fact, the benefits in Ohio and Illinois are much better than Indiana. And so basically the theory is that in Indiana we're going to attract more business by keeping workers' compensation benefits low. Well, the proof's in the pudding, and the jobs are all in Illinois and Ohio, and so apparently this theory hasn't worked either. And so I've had really experienced and capable workers' comp lawyers actually choose to file the case in Illinois, which is the home office of the employer, and not per se in the home state of the employee. And these trucking cases is a good example. You can also see that in construction claims. And so there's a lot of situations where you can actually choose your jurisdiction in order to try to get a better remedy. Now you can't just willy-nilly pick a state like Ohio if you think that that would be better than to file it in Indiana. There has to be some kind of a connection there, like the fact that the home office of the company is located in that state. So basically, there's a lot of issues here with workers' compensation. Benefits in Indiana are very low. They've been kept very low for many years. You know, at one time, for instance, if someone was killed on the job, and this is just during my career, the compensation, lifetime compensation was like $96,000, something like that. It has gone up over time. I think it's up around 155 or something like that. But I mean, you know, in the course of a lifetime, if you had this case as a civil tort, I know that there's a lot of these civil torts that net at least $1 million, you know. So it's a character flaw, I think, in the whole situation, that they just were anti-compensating workers who are injured. The problem with that, I think the downfall of that is that then they turn to other systems, and once again the employer gets off the hook, and things like Social Security, Medicaid, and a number of these other agencies in the federal government have to pick up the slack. So in the long run, the taxpayer actually pays for what many think is good conservative policy. And so, you know, we have these situations where someone's totally disabled, they can't work anymore, they get nickels and dimes from the workers' comp board, and then they turn around and have to look, well, where else? Some of them just die, they just starve to death, they don't, you know, they don't look. But there are people out there that go and ask a lawyer. So you could be in that situation too, where you get somebody that's basically hurt pretty bad, but the compensation isn't really going to be enough. So then you look to other administrative actions, like Social Security, for example, and try to see what else is available out there. Well, basically, if you look at this Title 631, then you'll see it's a long, lengthy section, administrative code section. Some of these things have been overruled by later statutes. You want to double check that. You can also understand a basic nature of this, that it is, if this is in any way work related, the medical bills from that accident are the responsibility of the employer, not the employee. Now this is a big problem, because if you're going to be working in a law office and you're going to have a workers' compensation employee plaintiff that wants benefits, they get done all the time. They get bills, bills, bills from all these doctors, and that's just not the way it's supposed to be. Bills are supposed to go directly to the employer. They're supposed to be paid. This is not an issue of health insurance. This is outside health insurance. It is an issue of workers' compensation, and one of the big aspects of this is to pay the medical bills. The employer has to pay the medical bills. So I've seen over and over again where people are subjected to collections for workers' compensation accidents, and it's just a constant struggle. You try to send them back to the employer says no, so then they go back after the employee, and then eventually, if you ever do finally get the thing settled, then the employer does pay, but not until there's been all this angst and argument and, you know, anxiety on the part of the employee, having to put up with calls, letters, bills, bills, bills. You know, so that's another big thing that I've seen in workers' compensation, you know, over the years. Some of the things too where it's kind of borderline is, let's say that someone is a gang member and they're working in a factory somewhere, and then a member of a different gang stabs them on the job place. Well, is that the employer's responsibility? Probably not. I mean, it's one of those situations where, you know, it would be a tough one. It's a fact-sensitive situation, but, you know, we get into some of these criminal activities and things like that. Any kind of criminal activity actually takes any litigation out of the civil sector. And, you know, so in other words, you have to approach all litigation, even workers' compensation, with what we call clean hands. And what that means is that you can't somehow, this can't be a setup, this can't be any kind of a case where someone is doing something completely other than their employment-related activities. Now, you know, there's other agencies involved here like OSHA and some different things like that to consider. OSHA does not have any power over Workers' Compensation Board, but sometimes they act like in parallel to one another. OSHA's real concern is to correct the problems with any machinery, practices, anything like that, dangerous practices in the workplace that could cause these accidents to happen. Again, the workers' comp case is really more concerned about the individual that has been injured and what their future is going to be and how to compensate them for this accident that happened. So don't get OSHA and workers' compensation confused. Basically, I'd say, you know, look through this Title 30 or 631. I posted it up there with my discussion if you want to look at it. There are some copies of forms. There's a number of different things. Dig into it and just kind of, you know, hone in on something. Look at different parts. The plaintiff, the complaint, the defendant, the answer, you know, depositions. You know, what are the pleadings, for example? It says that everything has to be at least typewritten. I don't know if anybody can find a typewriter, but what they're saying is they don't want you to take out 8.5 by 11 piece of school book paper and write out your complaint. That's not acceptable. So a number of little nuances here. Take a look at them. Hope this has been helpful, and I'll be back with you on another chapter with another video lecture. Thanks for watching.